how could you prove that you've been violated by a debt collector after disputing your debt? The law we're going to talk about today is 15 U.S.C. 1692 E8, the number 8, okay, coming out of the Fair Debt Collection Practice Act. And we're going to talk about this law because there are 5 things you need to prove when you're trying to potentially take these people to court after violating you. So this section of the law, we're going to talk about 5 things that you need to prove when trying to get your remedy from these debt collectors. So let's get into it. So you guys just Google 15 U.S.C. code 1692 E8 and you're gonna pull up false or misleading representation. We got to clearly understand and make sure that we are Googling words if we don't understand what it means. We're going to be talking about basically if you are disputing a debt and a debt collector pretty much violates you by not doing what they're supposed to do in regards to that debt you disputed. So we're going to jump right into it. I want you guys to understand what part of the section of the law you need to apply when trying to get your remedy from a debt collector. So we're going to start at the top. So it say a debt collector may not use any false, deceptive, or misleading representation or means in connection with the collection of any debt without limiting the general application of the foregoing. The following conduct is a violation of this section. So right there, Congress is telling us anything after what we just read is a violation if the debt collector do such thing. So we're going to jump down. So we know they're saying anything they do after this is a violation. So we're going to go to the section 8, the number 8 that I had referenced to earlier. So it says communicating or threaten to communicate to any person credit information which is known or which should be known to be false, including the failure to communicate that a disputed debt is disputed. Okay, so let's read that again. Communicating or threaten to communicate to any person credit information which is known or which should be known to be false, including the failure to communicate that a disputed debt is disputed. So what Congress is telling us, y'all, right there, that once you dispute with a debt collector and they fail, that the failure to communicate that the debt has been disputed is a violation. So if you have disputed something and they fail to tell the consumer reporting agencies that you disputed that debt, that's a violation. So they shouldn't be reporting to the consumer reporting agencies that, A, this person is 30 days late, or A, this person still owes, this person did this. Only thing that they should be communicating to the consumer reporting agencies is that the debt is disputed. That's what the law says. So I want to talk about 5 things you need to prove because it is very easy to get your remedy from a debt collector. Debt collectors are somebody who's bought your information from another company who had your information prior to them getting it, and they're pretty much violating you by putting this information on your consumer report or even trying to come after you for money. Okay, so there's 5 things you want to do when you're trying to get your remedy. And by the way, I want to say this is not legal advice at all. This information is just for educational purposes. Okay, so 1, you have to prove you disputed the debt, y'all. Sending a letter, that is a great way to prove that you disputed the debt. You always want to keep your original copies, okay? 2, prove that the debt collector got your dispute. So how are you going to do that? So you have to prove that they got your dispute. So you have to send your dispute letter certified mail return receipt. You have to, and this is why I tell y'all, if you want to learn how to mail for free, look at the link in my bio, email me. I got that information. You can learn how to mail for free because it can get really expensive trying to certify all documents every time you're trying to dispute with somebody. So you got to prove it landed in somebody's hand. 3, you have to prove what date the debt collector received your dispute letter. So if you're sending it certified mail, there's a signature that have to take place. So you got your signature along with the date, okay? That's going to prove that they have received your letter. That's why it's so important to make sure it's certified, because they have to sign it and the date is going to be on there. So now you're playing the waiting game. After you have sent everything off, You certified everything. You're waiting 30 days. When you are disputing with debt collectors, you want to give them at least 30 days according to the law to respond. So 4, you want to make sure that you pull your credit report. Get an updated copy of your credit file. You don't want to pull from Credit Karma. Pull your reports from somewhere like annualcreditreport.com, smartcredit.com, or even Identity IQ. But make sure that you get accurate information, because pulling from Credit Karma, y'all, it's not your true FICO score and it's not updated information. So you want to make sure that information is accurate. Okay. So 5, the 5th thing that you want to make sure that you can prove, you want to check for any updates regarding that debt that you disputed. Okay. So let's say on March 1st, the debt collector receive your dispute letter. They signed for it. You know they signed for it. Okay, so they got it. On March 29th, you notice that there was a update to your file regarding that debt you disputed, but the update is not reflecting as disputed. Okay, remember the law said that they should only be updating that the debt has been disputed if a consumer disputed debt. Well, there you have it. That's the violation, y'all. That's what they have violated. The debt collector has violated 15 USC 1692 EA. So in order to file a claim and sue the debt collector, you want to be well prepared and make sure you have checked off all 5 things. You can't sit and say, oh, I know they violated me, they're not responding. If you can't prove all 5 things that I talked about, it's going to be impossible for you to get your remedy when you are in court. It's not about what you know. It's about what you can prove. You have to have something that can back you up in court. Okay, court starts in the mail. You have to keep documentation. You have to get things certified. It is so important. You have to have proof that you disputed the debt. You have to have proof that they received it. You have to have proof what date they received it. You want to pull your credit report and you want to look for the updates. Now, if a debt collector refuses to say as disputed and they just freeze the account, what you want to do is contact the consumer reporting agency and let them know, hey, I got an account reporting and it's just frozen. There is no activity going on. So what the consumer reporting agency is going to do is they're going to contact the debt collector, and this is going to trigger them to update it. Now, if they choose not to update your account, then hey, whatever. You got them 5 things that you can prove to take them to court. You want to keep your documents showing that you have reached out to the consumer reporting agencies, trying to get them to fix this information. You reached out to the debt collector. Nothing is happening. Okay, so if you can prove them 5 things, you got a claim. Don't wait to be great.